Welcome to The Deep Dive, the show engineered to cut through the noise, taking a stack of sources, articles, and research, and meticulously extracting the most potent nuggets of knowledge.
Our mission: to arm you with deep, well-informed insights, often surprising, always impactful.
Today, we're plunging into something foundational, something that underpins the very architecture of our government, the shifting balance of power between the courts and the presidency. It's a dynamic tension, an ever-evolving struggle, often playing out in the arcane language of legal briefs and judicial orders, but its consequences ripple through the lives of every single one of us.
Indeed, we're dissecting the fundamental checks and balances that are meant to define our republic and observing how they're currently being reevaluated, reinterpreted, and, in some rather dramatic cases, fundamentally reweighted.
Yeah, reweighted is a good way to put it.
Our sources today offer a panoramic view, from rigorous legal analyses penned by constitutional scholars to incisive journalistic reports on unfolding events, giving us a truly comprehensive understanding of this incredibly vital topic.
Right.
It's a fascinating study in institutional adaptation, or perhaps recalibration.
Okay, let's unpack this with a moment that brought this tension into sharp focus, a really tangible flashpoint from early 2025. Picture this. Federal Judge Denise Casper, presiding in a Boston courtroom, she's faced with a sweeping executive order from President Donald Trump. This order was, to put it mildly, audacious in its scope. It mandated that voters nationwide prove their citizenship, a significant new hurdle, and it barred the counting of mail ballots received after Election Day.
Wow. Okay. Big changes.
Big changes. These were not minor tweaks. These were profound changes to federal election procedures, which historically have been the purview of individual states.
Right. States usually run elections.
Exactly. It was a direct executive foray into an area traditionally reserved for legislative bodies and state administration.
What's truly fascinating here is Judge Casper's immediate and decisive response. She didn't waver.
No hesitation.
She issued a district court injunction, a powerful legal instrument that instantly halts a government action.
Right? Puts the brakes on.
Completely. This injunction unequivocally blocked the implementation of Trump's executive order. Her legal reasoning was not just clear, it was deeply rooted in constitutional principle. The Constitution does not grant the president any specific powers over elections.
Simple as that, huh?
Pretty much. This ruling wasn't just a technicality. It was a firm constitutional boundary drawn, preventing what was widely viewed as a direct executive overreach into state-run election procedures. It was a clear demonstration of the judiciary acting as a bulwark.
And that, for us, is a crucial starting point, isn't it? A lower court, a federal judge, standing firm, holding the line, acting as a vital guardrail against a potentially boundless executive. But here's where the narrative takes a profoundly counterintuitive turn, where it gets really interesting, because simultaneously, at the very pinnacle of our judicial system, the Supreme Court was embarking on an entirely different course.
Yeah, a very different path.
They weren't merely holding a line, they appeared to be fundamentally redrawing it, often in ways that distinctly empowered the presidency. It's almost as if two different constitutional maps were being sketched at once.
Precisely. While Judge Casper was affirming a traditional Madisonian understanding of limited presidential powers, the Supreme Court, particularly in the landmark case of Trump v. United States in 2024, was charting jurisprudential new territory.
Okay, that's the immunity case, right?
That's the one. This decision, emerging from the High Court's conservative majority, granted a former president something truly unprecedented in our nation's history: broad immunity from criminal prosecution for what they termed official acts.
The first time ever.
The very first time. The Supreme Court recognized presidential immunity for conduct that occurred within the president's constitutional powers. This isn't just a slight adjustment. This represents a dramatic reweighting of the separation of powers, significantly tilting the balance of accountability and authority decisively toward the executive branch. It introduces a novel dimension into how we understand presidential accountability, or maybe the lack thereof.
So if we synthesize these two seemingly contradictory judicial trends, what does this all mean for the architecture of American governance?
That's the key question.
We have lower courts spread across the country, actively putting up a fight, diligently trying to uphold established constitutional boundaries and individual rights.
Right, the guardrails.
Yet, at the same time, the highest court in the land is, through new legal doctrines and interpretations, seemingly creating significant gaps, even chasms, in those very guardrails. This isn't merely a legal curiosity or a fascinating intellectual exercise. It's a profound, fundamental shift in the structural map of power within the U.S. system, consistently and alarmingly favoring the presidency.
It really challenges our long-held assumptions about how government should function.
It does.
This immediately raises a critical question for anyone interested in political science or constitutional design. What are the long-term implications of these divergent yet simultaneous trends?
Yeah, where does this lead?
Our mission for this deep dive is to explore exactly that. We'll analyze specific cases with a forensic level of detail, unpack the intricate legal reasoning or lack thereof behind these pivotal decisions.
Okay.
And connect what might at first seem like individual rulings to the broader principles of constitutional design, democratic governance, and the very stability of our republic. We want to understand the why behind these seismic shifts.
And to fully appreciate the contours of this shift, we'll also broaden our lens to include some vital international examples.
That's important context.
We'll look at countries like Poland and Israel, nations that have faced their own intense challenges to judicial independence, where the balance of power between the executive and the judiciary has undergone dramatic and often fraught transformations.
These comparative perspectives offer some crucial context, providing cautionary tales and valuable insights into what happens when judicial independence is challenged or even systematically dismantled.
And why that matters so deeply for the U.S. context.
Absolutely. It allows us to view our own situation through a broader historical and global lens.
Ultimately, this isn't merely about parsing legal minutiae or engaging in abstract constitutional theory.
No, it's much bigger than that.
This deep dive is about understanding the very architecture of our government, the foundational checks and balances that are meant to ensure stability, prevent the concentration of power, and protect individual liberties.
We'll delve into philosophical debates about constitutional interpretation and the scope of executive power, exploring how different interpretive philosophies can lead to vastly different institutional outcomes.
Right. We're asking, what does this all mean for the future of our republic?
And how should an informed citizen, one who appreciates logic, history, and the intricate dance of power, interpret these complex, evolving dynamics that are reshaping our nation?
Let's begin our journey into Chapter 1, Lower Courts as Guardrails, Injunctions and Immediate Checks. Even in an era marked by executive actions that are often perceived as aggressive and boundary-pushing, the lower federal courts, comprising thousands of trial judges and appellate panels spread across the entire country, have consistently shown they can step in.
They really have.
They've served as the very first line of defense, the immediate constitutional responder, upholding the rule of law against what they perceived, in numerous instances, as executive overreach.
They are the frontline arbiters, translating abstract constitutional principles into concrete protections.
And their primary tools in this critical function are injunctions, both preliminary and permanent, and temporary restraining orders, or TROs.
Right. To visualize this, think of these judicial orders as legal stop or pause buttons.
Like hitting pause on a government plan.
Exactly. A preliminary injunction, for instance, is an order from a judge that temporarily halts a government action. It's issued typically after an initial hearing where the judge assesses whether the party seeking the injunction is likely to win on the merits of their case.
Makes sense.
And whether they would suffer irreparable harm if the action proceeded. A TRO, on the other hand, is even more immediate. It can often be issued without a full hearing, designed to prevent immediate, dire, and irreparable harm before a more comprehensive legal process can unfold.
So TROs are for emergencies.
Pretty much. These orders possess immediate, undeniable power to halt governmental actions, creating real-time checks that compel the executive branch to pause, reconsider, or even withdraw policies.
They force a timeout.
They do. They are truly the on-the-ground defenders, translating constitutional theory into practical protection for individual rights and established legal principles. They create immediate legal friction, forcing the executive to slow down.
Let's delve into our first case study illustrating this power. Press access and the First Amendment.
Okay, important one.
In March 2025, we saw a direct attempt to control the flow of information. The Trump White House explicitly barred Associated Press journalists from gaining access to the Oval Office and Air Force One spaces traditionally open to the White House press corps.
Right, standard access for major outlets.
The stated reason for this ban was AP's refusal to use the administration's preferred renaming of the Gulf of Mexico.
Over a name change. Seriously.
That was the stated reason. This wasn't just a squabble over semantics. It was a clear, direct attempt to leverage executive power to punish a major news organization for not complying with a non-official, politically motivated directive.
So basically trying to control their editorial independence.
That's how it looked.
And here's where the judicial guardrail immediately came into play. Federal Judge Trevor McFadden, notably himself a Trump appointee, intervened swiftly.
Interesting. A Trump appointee pushing back.
Yes. In April 2025, he issued a preliminary injunction. This order wasn't ambiguous. It specifically mandated that the White House restore AP's access to these presidential events and spaces.
So let them back in.
Let them back in. Judge McFadden's ruling articulated a core First Amendment principle with striking clarity. If the government opens its doors to some journalists, it cannot then shut those doors to other journalists because of their viewpoints.
Can't pick and choose based on what they write.
Exactly. This wasn't just a victory for AP. It was a resounding, immediate message to the administration and indeed to all future administrations. It served as a potent constitutional reminder that the executive branch, regardless of its preferences or political frustrations, cannot punish news organizations for unfavorable coverage or for refusing to comply with non-official partisan directives.
Upholding the free press.
Absolutely. It upheld the essential role of a free and unburdened press.
The administration, predictably, attempted to delay compliance and pursued appeals, trying to exhaust the legal avenues.
Standard playbook sometimes.
But despite these tactics, the court's stance on press freedoms being fundamentally unabridgable by executive fiat was unmistakably clear and enduring.
The principle stood.
This case powerfully underscores the judiciary's capacity to protect the essential function of a free press as a vital check on government power, ensuring crucial access and preventing arbitrary retaliatory measures.
Yeah, it's about government transparency too, right? The public's right to know. If we connect this to the broader picture, the ability of lower courts to issue these immediate injunctions, as compellingly seen in the AP case, demonstrates their critical, real-time role as frontline defenders of fundamental individual rights and the principles enshrined in the Constitution.
So these injunctions, they buy time.
They buy crucial time, they halt potentially damaging executive actions in their tracks, and they establish clear legal boundaries that the executive branch must then contend with. They prevent policies from taking immediate, irreversible effect, allowing for a more thorough and deliberate legal review process to unfold.
So it slows things down for a proper look.
Exactly. This immediate judicial intercession is vital for preventing rapid erosion of rights.
Okay, moving on. Our next case study reveals how these judicial guardrails extended to protect vulnerable populations, specifically in the context of immigration.
Right.
This one involves students and universities pushing back. The Trump administration's hardline approach to immigration enforcement extended directly into college campuses shortly after his return to office. Specifically, immigration officials took drastic action. They revoked or summarily terminated the visa records of thousands of foreign students.
Thousands. Just like that.
Said it just like that. The direct, immediate, and dire consequence of this action was that these students were instantly put at grave risk of deportation.
Wow. That's devastating for them.
Absolutely. Facing not just disruption to their education, but potential expulsion from the country and the shattering of their academic and professional aspirations.
What's truly compelling here is the immediate, widespread, and remarkably effective response this executive action triggered. Students and universities across the country did not passively accept this. They mobilized rapidly and strategically.
They fought back.
They fought back vigorously in court, and crucially, they won not in isolated pockets, but through a broad, coordinated judicial resistance. Judges all over the country issued numerous temporary restraining orders, or TROs.
Those emergency orders again.
Yes. These TROs had a critical protective scope. They explicitly protected over 200 affected students by blocking the government from deporting them or unilaterally altering their immigration status.
So the courts stepped in across the board.
It was a decentralized, yet powerful network of judicial actions responding to a centralized executive directive.
A particularly prominent example was Harvard University, which obtained a TRO specifically against Trump's sweeping proclamation barring foreign nationals from studying there.
Harvard took direct action.
They did. The judge's rationale for issuing this TRO was both clear and deeply reasoned. They found that Harvard, as an institution, would suffer irreparable harm if the order was enforced harm to its academic mission, its faculty, and its international standing.
Makes sense. International students are vital.
And critically, the judge made an important observation, noting that Trump's move appeared to be direct retaliation against the university for its perceived political leanings, thereby infringing upon academic freedom.
So a potential First Amendment issue there, too. Academic freedom.
Exactly. A foundational principle crucial for any robust educational institution that values open inquiry and diverse intellectual exchange. It was a defense not just of students, but of the very idea of academic autonomy.
Faced with dozens of such judicial orders and the immediate widespread legal challenge that paralyzed their policy, the administration was forced to concede, at least temporarily, in April 2025.
They backed down.
Temporarily, yes. This outcome meant they had to restore hundreds of foreign students' legal status, while frantically scrambling to devise a new, legally compliant policy that could withstand judicial scrutiny.
So the court's forced to rethink.
Absolutely. This case illustrates powerfully how individuals and institutions, when faced with what they perceive as executive overreach or arbitrary action, can effectively leverage the courts to halt such actions, even if the relief provided is provisional.
Even temporary relief matters.
Immensely. It also emphasizes the proactive, vital role of academic institutions in defending their autonomy and the rights of their students through vigorous legal means, showcasing a decentralized yet highly effective form of resistance within the constitutional framework. It's a testament to the power of collective legal action.
Let's delve into what was perhaps the most audacious and significant attempt to rewrite constitutional norms through executive fiat, the birthright citizenship order, which was ultimately blocked.
Yes, this was huge.
This sweeping executive order, issued on January 20, 2025, just after the president's return to office, aimed at nothing less than ending birthright citizenship for children born in the U.S. to certain immigrants.
Let's try to change the 14th Amendment by executive order.
Essentially. The directive was unambiguous. Federal agencies were instructed to deny U.S. citizenship to American-born children unless at least one parent was a U.S. citizen or a lawful permanent resident. This was a direct assault on what has long been considered a bedrock principle of American constitutional law, directly challenging the very definition of who is an American citizen.
This edict directly defied the unambiguous language of the 14th Amendment's Citizenship Clause. The clause states, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside."
Pretty clear language.
Very clear. For over a century, this clause has been consistently interpreted by courts and legal scholars to grant citizenship to virtually everyone born on U.S. soil, regardless of their parents' immigration status, with only narrow exceptions not relevant here.
So the EO flew in the face of established law.
Completely. Trump's executive order was not merely a reinterpretation. It was a stark, unilateral challenge to this long-held, deeply entrenched understanding, an executive attempt to redefine a cornerstone of American constitutional law without legislative or constitutional amendment.
A frontal attack, really.
It represented a direct, frontal attack on established precedent and the settled understanding of citizenship.
The judicial response to this unprecedented executive order was immediate, unified, and truly a wall of judicial resistance, as our sources vividly describe it.
A wall.
This wasn't just a few isolated rulings or dissenting opinions. Every single court that considered the merits of the order, without exception, found it likely unconstitutional.
Every court. Unanimous
among those that ruled on the merits. This widespread consensus reflected a deep-seated rejection of the executive's attempt to unilaterally alter such a fundamental constitutional principle. Multiple district judges from different circuits swiftly issued nationwide injunctions to halt its implementation.
Nationwide injunctions, so stopping it everywhere.
Exactly. Demonstrating a consistent and widespread legal consensus against the order and preventing its application across the entire country.
By August 2025, a fourth federal judge, Judge Deborah Boardman in Maryland, had also blocked the order, reinforcing this judicial unanimity.
Okay, Judge Boardman.
A crucial procedural detail here, appealing to those interested in the mechanics of the law, is that her ruling specifically certified a plaintiff class of at-risk children.
A class action, basically.
Precisely. For clarity, a plaintiff class means a large group of people who are in a similar situation and share common legal claims. By certifying such a class, Judge Boardman ensured nationwide relief, meaning her ruling applied not just to the specific individuals who filed the lawsuit, but broadly to all similarly situated children across the country.
Smart legal move.
Very. This was a strategic move designed to address concerns that some injunctions might be geographically limited, ensuring that the protection extended broadly. Judge Boardman's reasoning underscored with absolute clarity that Trump's order interpreted the 14th Amendment in a way that the Supreme Court has resoundingly rejected and no court in the country has ever endorsed.
So, legally baseless in her view.
Essentially, yes. A very clear and forceful statement about the profound legal illegitimacy of the executive order, rooted in its profound departure from established constitutional interpretation.
The significance of these numerous lower court injunctions, many of them issued by judges appointed in earlier administrations and therefore presumed to be less politically aligned, is profound.
Right, not just judges from one party.
They powerfully demonstrated the judiciary's consistent and resilient capacity to slow down, push back, and ultimately halt executive erosion of fundamental rights.
Showcasing the judiciary's commitment.
Exactly. Upholding deeply entrenched constitutional principles, even when faced with aggressive, boundary-pushing executive challenges. These decisions provided tangible, immediate relief and upheld the very fabric of our constitutional order.
So if we take a moment to summarize how lower courts have functioned as crucial guardrails, like a quick recap.
Yeah, let's do a micro recap here, around the 5-minute mark.
Okay. We can highlight their overarching mission. They acted as critical, real-time constitutional enforcers. They upheld established legal boundaries and provided rapid relief against executive overreach.
Using injunctions and TROs.
Right. The primary tools they consistently utilized were preliminary injunctions and temporary restraining orders, which became indispensable in holding the line against potentially immediate and irreversible executive actions.
And they protected a range of rights.
Definitely. Their scope of protection extended across a diverse array of fundamental rights and principles, blocking election-related executive orders to protect voting rights, safeguarding journalists from viewpoint-based exclusion, as seen in the AP case, shielding foreign students from arbitrary visa terminations and deportation in cases like Harvard's, and powerfully defending birthright citizenship against executive challenges through widespread, sometimes nationwide, injunctions like Judge Boardman's.
So concrete, immediate successes for those challenging the executive.
Yes, absolutely. These are concrete, immediate successes.
It's important to remember, though, that these vital wins, while providing critical temporary relief, were often provisional and sometimes geographically limited, even if some, like Judge Boardman's, cleverly achieved broader class-wide relief.
Right, they weren't always the final word.
These judicial interventions effectively bought crucial time and set important legal precedents, creating a pause, but the final definitive outcomes of these challenges always hinged on higher courts.
Which leads us to...
Exactly. And here's the lurking factor, the crucial foreshadowing for our next chapter. During the same period, the Supreme Court was increasingly inclined to side with the executive, often poised to undo the lower court's diligent, painstaking work.
The plot thickens.
It creates a fascinating and somewhat precarious tension within the judicial system itself, where one level builds a wall and another seemingly finds a way around it, or maybe even dismantles it.
Okay. So let's shift gears.
All right, now that we've witnessed the crucial role of lower courts in standing as immediate guardrails, let's pivot our attention to the highest court in the land.
The Supreme Court.
This brings us to Chapter 2, the Supreme Court's new map, shifting power toward the executive.
A very different picture emerges here.
If the lower courts were painstakingly putting up defensive guardrails, the U.S. Supreme Court, under Chief Justice John Roberts and its entrenched 6-3 conservative majority, has been busy charting a fundamentally new jurisprudential course in the intricate domain of the separation of powers. And that course, simply put, has demonstrably, consistently, and significantly empowered the presidency. It's a remapping of constitutional authority.
It's more than just a series of isolated rulings. It's a distinct and pervasive pattern. Since President Trump's return to office, the court has repeatedly intervened in his favor, often utilizing its less transparent emergency docket, a mechanism we'll delve into shortly.
The shadow docket.
Exactly. Crucially, beyond individual case outcomes, they've actively reshaped foundational legal doctrine to systematically expand executive authority. This isn't just about winning a few cases. It's a systemic, philosophical reorientation of power within the constitutional framework.
Shifting the balance.
Shifting the balance in profound ways that would intrigue any student of political philosophy or legal history.
And the clearest, most seismic example, the most dramatic illustration of the Supreme Court's reweighting of power, is undoubtedly the case concerning absolute immunity for official acts.
Trump v. United States.
Specifically, Trump v. United States, decided on July 1st, 2024. This was not merely a significant ruling, it was a blockbuster decision, truly unprecedented in the annals of American legal history.
A jurisprudential earthquake, you could say?
Absolutely. For the first time ever, in over 230 years of constitutional governance, the court recognized presidential immunity from criminal prosecution for a former president's official conduct. This created a new legal landscape for executive accountability.
Chief Justice Roberts, writing for the 6-3 majority, presented the core argument rooted in the concept of separated powers, contending that for the executive branch to function effectively, a president must have some immunity for acts performed within the scope of his duties.
The argument being they need freedom to act.
Essentially, yes. This reasoning is deeply tied to the idea that a president must be free to make difficult decisions without the constant specter of vexatious litigation or politically motivated prosecutions after leaving office. The scope of this immunity was then delineated. It was declared to be absolute for what they termed core constitutional powers.
Like signing bills, military command.
Exactly. Actions like signing bills into law, commanding the military as commander-in-chief, or granting pardons actions central to the executive function. But critically, for all other official acts, the immunity was deemed presumptive.
Presumptive. What does that mean exactly?
It means there's an initial assumption protection. The burden then shifts heavily onto prosecutors to overcome that presumption. They have to demonstrate that the act falls outside the scope of official duties, or that the presumption of immunity should be overcome under specific yet undefined circumstances.
So the default is immunity unless proven otherwise.
That's a good way to think about it. It effectively creates a default shield for presidential conduct.
So let's consider the profound practical implications for prosecutors attempting to bring a case against a former president.
It's a huge hurdle.
This ruling means they now face an extraordinarily high bar, a powerful presumption against criminal liability for anything a president did while in office.
Our sources emphasize that this was an astounding departure from historical practice, a complete break from prior judicial understanding. No Supreme Court had ever immunized a president or a former president from criminal law before.
Never happened before 2024.
Never. This decision, it's argued, deviated even from the court's own cited precedents and was seen by many legal scholars to expand presidential powers significantly, fundamentally leaving the powers of the presidency dangerously imbalanced within the intricate constitutional structure.
Dangerously imbalanced. Strong words.
Very. It's a shift from the idea that no one is above the law to potentially the president being above certain aspects of it for certain actions.
This immediately raises a critical question for any citizen concerned with accountability and the rule of law. What does this truly mean for executive accountability?
Right, the core issue.
By effectively shielding a president from prosecution for abusing official powers, even if those abuses were conducted under the guise of official acts, the court undeniably tilted the balance of accountability decidedly toward the executive branch.
President Biden himself issued a stark warning, stating that the ruling set a dangerous precedent, suggesting that the presidency will no longer be constrained by the law, thereby jeopardizing the fundamental American principle that no one is above the law. One Biden campaign official even more bluntly stated that the decision makes it easier for a president like Trump to pursue a path to dictatorship, suggesting a direct, perilous consequence.
Wow, that's quite a claim.
It is. The deeper implication is that this immunity doctrine fundamentally undermines one of the key constitutional checks on a rogue president, the prospect of legal consequences after leaving office.
And it does this in the name of separation of powers.
Paradoxically, yes. Reinterpreting the very limits of executive action in a way that empowers rather than constrains presidential conduct. It sets a new and potentially risky precedent for the balance of power.
So we've covered the dramatic shift initiated by the Supreme Court with the Trump v. United States decision, moving from lower courts acting as guardrails to the high court fundamentally altering the power balance.
Creating this unprecedented immunity.
Right. But this monumental shift wasn't limited to formal written opinions resulting from lengthy arguments. The court has also wielded its emergency powers in powerful yet far less transparent ways. This brings us to the shadowy yet incredibly impactful mechanism of the shadow docket and emergency levers.
Okay, let's talk about the shadow docket.
You've got the 10-minute mark now. Good time for this.
This mechanism operates largely out of direct public view, earning its shadow moniker. Since January 2025, the Trump administration leveraged this avenue by flooding the Supreme Court with an unprecedented number of emergency applications.
Flooding the court.
An unusually high number. The purpose of these applications was explicit and strategic: to bypass or quickly lift lower court injunctions, effectively asking the Supreme Court to step in immediately and reverse previous judicial decisions that had stalled executive policy.
So skipping the normal appeals process.
Pretty much, or at least fast-tracking the intervention. These weren't regular appeals. They were urgent requests for immediate relief, often before lower courts had even fully explained their reasoning.
And this shadow docket strategy paid off handsomely for the administration.
It seems so.
By mid-2025, the justices had ruled in Trump's favor in approximately 9 out of 13 emergency requests, with only 2 outright losses.
That's a high success rate.
It is. The characteristics of these orders are particularly notable and raise concerns about due process. They're typically unsigned, meaning no individual justice is directly named as author. They're often issued late at night, outside normal court hours.
Unsigned and late night. Sounds odd.
And they come with very little briefing or explanation, sometimes just a sentence or two. The immediate impact, though, was profound and practical. These orders gave Trump the green light to swiftly implement highly contentious policies.
Even while the cases were still ongoing.
Exactly. Even while the full litigation process continued or was bypassed entirely, it's like a fast-track system that prioritizes executive action.
We saw powerful, real-world examples of this shadow docket impact. For instance, the court's emergency orders allowed the administration to revoke humanitarian protections for hundreds of thousands of migrants, a policy lower courts had found problematic.
So policies blocked below got approved above quickly.
Yes. They also permitted the ban on transgender people from serving in the U.S. military policies that lower courts had explicitly blocked, citing constitutional concerns.
Another reversal.
Furthermore, the conservative majority let Trump proceed with mass federal workforce reductions and other executive actions aimed at downsizing government, despite ongoing legal challenges that argue these actions exceeded presidential authority.
So overriding those initial guardrails we talked about.
Repeatedly. These are crucial instances where the Supreme Court effectively overrode the initial guardrails painstakingly put up by the lower courts, demonstrating a willingness to prioritize executive speed over judicial deliberation.
And in a particularly significant order from late June 2025, the Supreme Court explicitly curbed the power of lower court judges to issue nationwide injunctions, specifically addressing the birthright citizenship order we discussed earlier.
Reining in the lower courts directly.
The message from the High Court was unmistakable and intended to rein in judicial activism. A single district court, they implied, should not be able to halt federal policy for the entire country. This was a clear signal of their intent to limit the power of the lower judiciary to create broad, sweeping roadblocks for the executive.
It's important to note a nuanced detail here, appealing to those who appreciate the tactical precision of legal strategy. While the justices did curb the general power of nationwide injunctions, they did carve out exceptions.
Oh, loopholes.
Specifically for class actions, and for cases affecting certain jurisdictions. And, as we saw with Judge Wardman's subsequent nationwide class-wide injunction, creative litigants and astute judges quickly exploited these very exceptions to still achieve broad relief.
Finding the seams in the new rules.
Exactly, finding the seams in the court's new framework. Yet, the underlying message from the Supreme Court was clear. They were actively seeking to rein in the lower court's perceived ability to universally check the president's agenda.
Limiting the brakes.
Signaling a systemic shift towards limiting the reach and impact of these protective judicial orders that had previously served as powerful brakes on executive power.
Dissenting voices within the court itself have been sharply critical of this trend.
Not surprising.
Justice Ketanji Brown Jackson, for example, accused the majority of donning emergency responder gear, not to extinguish controversy, but rather to fan the flames of it by hastily intervening.
Fanning the flames. Strong words again.
Her warning was stark and rooted in judicial philosophy. Rushing complex cases with scant process significantly increases the risk of error in judicial decision-making, undermining the very legitimacy of the court's rulings.
Basically, speed kills careful judgment.
Justice Sotomayor likewise lamented that lifting injunctions without full briefing invites untold harm, as it allows policies with potentially severe consequences to take effect before their full legal implications are understood.
But these objections haven't slowed them down.
But such objections, unfortunately, have not slowed the conservative majority's aggressive and systematic use of the shadow docket.
The overall effect of these shadow docket interventions is undeniable and quite profound. The Supreme Court has effectively acted as an accelerator for President Trump's executive ambitions.
Stepping on the gas, not the brakes.
Precisely. Systematically dissolving many of the judicial roadblocks that have been painstakingly erected by lower courts. It's an example of institutional power being strategically deployed, not through reasoned deliberation and full public view, but often through opaque rapid-fire orders to enable executive action, even against prior judicial resistance.
Shifting the default from pause to go.
Exactly. This fundamentally shifts the default from a pause to a go for presidential policies.
Okay, let's do another quick micro recap here, maybe around the 15-minute mark. We've covered the shadow docket.
Right. How the Supreme Court uses its emergency powers to quickly greenlight executive policies, often bypassing standard judicial review.
And the effect is accelerating presidential plans.
Yeah, even when lower courts had blocked them. It reinforces the idea that this accelerates presidential ambitions.
Okay, so beyond specific rulings and the shadow docket, the court is also engaged in a broader systemic reconceptualization of executive power itself.
Yes, a deeper philosophical shift.
This brings us to rewriting the separation of powers through what's known as the unitary executive theory.
The unitary executive, a big concept for constitutional scholars.
Very much so, and deeply resonant for those interested in political philosophy and constitutional interpretation.
This conceptual shift is absolutely fundamental to understanding the court's current trajectory. The underlying philosophy pushed by the court's conservative justices is a robust vision of the unitary executive.
Meaning what, exactly? One powerful executive.
In essence, yes. This doctrine argues for strengthened presidential control over the entire executive branch, asserting the president's ultimate, unchallengeable authority over all executive officials, agencies, and their subordinates.
Ultimate control.
In its practical implication, this has meant systematically upending long-standing arrangements that previously insulated some agencies and officials from direct White House domination arrangements, often seen as independent checks within the executive branch itself.
Getting rid of those internal checks?
Or weakening them significantly. It's just a more hierarchical, centralized power structure where all authority ultimately flows from and reports directly to the president.
Like a CEO of the government.
Pretty much. Making them akin to the CEO of the entire federal bureaucracy, capable of directing or dismissing any official or agency beneath them.
We saw a vivid and, frankly, quite alarming example of this theory playing out in real time in mid-2025, with the Supreme Court's majority allowing President Trump to take steps to dismantle the U.S. Department of Education.
Dismantle an entire department.
Trump had signed an executive order to effectively shutter the department, transferring its core functions and laying off half its staff. A lower court, recognizing the profound implications and potential overreach, froze the plan, labeling it an illegal end run around Congress's statute.
Because Congress creates departments, right?
Exactly. The lower court reasoned that such an action usurped legislative power, as only Congress, through its legislative authority, could create or dismantle a cabinet-level department.
But in July 2025, the Supreme Court summarily lifted that injunction.
Lifted it, just like that.
Just like that. This was, once again, an emergency order delivered with only a terse 6-3 explanation. It permitted the mass layoffs and reorganization to proceed immediately, overriding the lower court's reasoned pause.
Wow. So the dismantling could proceed?
Yes. The liberal justices, in their stark dissent, issued a powerful warning, accusing the court of handing the president the power to repeal statutes by firing all those necessary to carry them out.
Repealing laws by firing people.
Effectively allowing a president to nullify laws he dislikes by simply eliminating the personnel responsible for their enforcement. Justice Sotomayor's specific caution was particularly vivid. Such moves, she argued, allow a president to hollow out laws he dislikes.
Like civil rights enforcement or student loans.
using the concrete examples of firing staff who enforce educational civil rights or manage student loans, thereby functionally eradicating these vital programs without any legislative action.
So the court enabled this.
The majority's underlying theme here consistently reflected a greater deference to executive power and a fostering of skepticism towards independent checks on presidential authority, pushing for a streamlined, top-down executive.
And it's not just about specific departments or mass layoffs. The Roberts Court has also been systematically chipping away at the broader administrative state through other landmark decisions.
Right. Attacking the regulatory state.
They've been curbing regulators' latitude under doctrines like Chevron deference, which historically meant courts would often defer to an agency's reasonable interpretation of an ambiguous statute that Congress had passed.
Less deference to agencies now.
Less deference, essentially giving agencies less independent room to interpret and implement laws. They've also broadened the major questions principle.
What's that?
It requires clear congressional authorization for agencies to act on issues of vast economic or political significance rather than allowing agencies to act based on general statutory grants.
So agencies need explicit permission for big things. What's truly paradoxical and critical here is that while these actions seem to be constraining agencies and limiting bureaucratic power, they actually, and perhaps perversely, enhance presidential power.
How does that work? Less agency power means more presidential power.
Exactly. Because agencies are now constrained unless the president himself explicitly directs them. This channels more power directly to the Oval Office, making the president the central point of control for virtually all significant administrative action.
I see. Control flows upwards.
Precisely. The consistent pattern is a profound structural shift that enhances the president's ability to direct or effectively disable the executive branch at will without prior consultation or congressional approval.
Fits with the unitary executive idea.
Perfectly. This aligns perfectly with a long-held conservative goal of clarifying that agency officials ultimately answer directly and unequivocally to the elected president, rather than operating with any significant degree of independent, statutorily derived authority.
And the implication.
The critical implication for our constitutional system is that if a president is bent on undermining institutional safeguards or particular laws he dislikes, the legal framework, as now interpreted by this court, will pose fewer, if any, hurdles.
Fewer roadblocks from the courts or agencies.
As one analysis observed, the Roberts Court has unequivocally embraced a broad account of presidential power, while simultaneously pulling back on the autonomy of regulatory authorities, centralizing power within the presidency.
So, to sum up this dramatic remapping by the Supreme Court, it fundamentally redraws the lines of our governmental system, shifting the equilibrium.
Definitely redraws the map.
It significantly narrows the avenues by which courts, and by extension, perhaps even Congress, can effectively constrain a president's actions.
Less constraint.
Conversely, it vastly amplifies the avenues by which a determined president can act unilaterally, often with little judicial impediment. This is a profound structural reorientation with significant long-term implications for governance.
Okay, let's consolidate these key points concerning the Supreme Court's trajectory in a kind of mega recap for this chapter.
Good idea. The flashcard version.
Right. Their core trajectory is unequivocally charting a course that significantly empowers the U.S. presidency, centralizing authority within that office.
Point 1, more presidential power.
Point 2, the landmark immunity ruling in Trump v. United States in 2024 was unprecedented. The first ever recognition of presidential criminal immunity for official acts.
Immunity for official acts.
This immunity, absolute for core powers and presumptive for all others, creates an extraordinarily high bar for prosecution and decisively tilts accountability away from the executive branch.
Less accountability.
Third, the shadow docket has acted as a systemic accelerator. Through frequent emergency applications and quick, often unsigned orders, the court has consistently green-lighted contentious executive policies that lower courts had previously blocked.
Shadow docket speeds things up for the president.
This also included actively restricting the power of nationwide injunctions, thereby curtailing lower courts' ability to universally check the president's agenda.
Reining in lower courts.
Finally, the court is actively redefining the separation of powers through the unitary executive theory, strengthening presidential control over the entire executive branch and allowing actions like the dismantling of the Department of Education, despite lower court resistance.
Unitary executive boosts president's control over agencies.
This dramatically increases the president's ability to direct or disable federal agencies and laws at will, significantly reducing traditional checks on executive power. The overall effect is the systematic reduction of judicial avenues for constraining the executive while amplifying the president's unilateral power.
Less judicial constraint, more executive power.
It's a fundamental re-architecture of constitutional control.
Wow. Okay, now let's widen our lens for Chapter 3. Comparative perspectives, Poland and Israel.
Good. Seeing how this plays out elsewhere is crucial.
It's absolutely crucial to understand that the United States is not operating in a vacuum when grappling with this delicate and often fraught balance between courts and executive power. This is a global phenomenon.
That's profoundly true. Other democracies, both mature and nascent, offer powerful cautionary tales. They vividly illustrate how quickly constitutional guardrails can be eroded, particularly when the judiciary itself,
A supposed guardian.
the very institution designed to uphold those guardrails, is systematically weakened or overhauled by political forces. This provides a crucial comparative lens through which to understand the current dynamics unfolding here in the U.S.,
Learning from others' experiences.
offering us a glimpse into potential futures and indeed present realities if certain trends continue unchecked. It allows for a more philosophically grounded understanding of the fragility of democratic institutions.
Let's start with Poland, a stark and compelling example of what critics widely term court packing in slow motion,
Yeah, Poland has been a major case study.
and the subsequent erosion of judicial independence. Since coming to power in 2015, Poland's Nationalist Law and Justice Party, or PS, embarked on a sweeping, deliberate judicial overhaul.
This wasn't a sudden coup, but a systematic, step-by-step approach to reshape the judiciary, often described as methodical dismantling of judicial autonomy.
How did they do it? What were the mechanisms?
The mechanisms of this overhaul were quite specific, ingenious, and ultimately deeply impactful. First, PS legislation drastically altered the judicial appointment system, systematically stripping power from independent judicial councils and giving the parliament, which they controlled, a significantly greater, indeed decisive, say in selecting judges,
So politicians picking the judges.
pretty much politicizing the very entry point into the judiciary. Second, they created new, highly controversial disciplinary regimes explicitly designed to punish judges for rulings deemed unpopular by the government or for perceived insubordination,
Punishing judges for their rulings.
effectively creating a chilling effect that pressured judges to rule in a politically favorable manner. This meant that judges could face fines, demotion, or even dismissal for exercising their judicial independence.
Wow.
As a direct consequence, many experienced judges were forced into early retirement under new age limits, creating numerous vacancies that were then strategically filled with pro-government jurists, particularly in the crucial Constitutional Tribunal and Supreme Court,
Changing the makeup of the courts.
fundamentally changing the ideological and political composition of the highest courts.
PS leaders claim these drastic moves were necessary to purge lingering communist-era holdovers from the judiciary and to make the courts more efficient and accountable to the people, framing it as a vital reform.
The reform argument.
However, this justification was met with widespread and forceful international condemnation. The European Union, along with various international human rights watchdogs and legal bodies, vehemently blasted these actions as direct, undeniable attacks on the rule of law and the fundamental principle of judicial independence.
So the EU saw it as an attack, not reform.
They saw it as a deliberate subversion of democratic norms.
The consequences of this systematic overhaul were profound and immediate for Poland's democratic health. The result was a judiciary whose independence came into profound question. It was widely perceived as a flawed system by Poland's pro-EU opposition, which has since been scrambling, with limited success, to undo the changes.
And international consequences, too. Fines.
Yes, severe and financially impactful. The European Union, in an unprecedented move, even fined Poland over $320 million for systematically undermining judicial independence, directly illustrating the severe erosion of the rule of law and its international ramifications.
A huge fine. That's significant.
Poland's case offers a clear, sobering demonstration of how executive-aligned legislators can strategically reweight the intricate system of checks and balances, not through formal direct constitutional amendment, but by simply refilling courts with loyalists and intimidating or even removing dissenting judges.
So undermining independence from within.
Exactly. The critical takeaway is chillingly clear. Courts can no longer serve as effective independent guardrails if they effectively become by design or by intimidation, an arm of the ruling political party, losing their impartiality and their function as a separate branch of government.
Okay, another quick micro recap maybe. Around the 20-minute mark, Poland.
A clear example of executive legislative branches directly undermining judicial independence through structural changes like court packing and disciplinary regimes.
Turning courts into political tools.
Pretty much neutralizing their checking function. Now let's transition to Israel, where a similar but distinct battle for judicial power is playing out, also with unique and intense dynamics.
Right. Israel's situation has been in the news a lot.
Israel presents a particularly compelling case. It is a mature, vibrant democracy, traditionally characterized by a highly powerful and activist Supreme Court that has often served as a bulwark for minority rights in the absence of a formal constitution.
A very active court, historically.
Very. However, a radical judicial overhaul has been the centerpiece of Prime Minister Benjamin Netanyahu's current right-wing coalition since 2023. This isn't just a political debate. It's a central government initiative designed to dramatically reshape the balance of power.
Specifically targeting the Supreme Court.
Specifically by reining in the power of Israel's Supreme Court, which the coalition views as overly interventionist.
The proposed legislative changes within Israel's judicial overhaul are, indeed, incredibly significant and have ignited a profound national crisis.
What are they proposing?
They include legislation introduced to severely limit the Supreme Court's authority, for example, stripping the court of its long-standing power to strike down government actions it finds unreasonable or disproportionate.
Taking away the reasonableness standard.
Yes. One bill, passed in July 2023, amid significant uproar and mass protests, specifically bars judges from using the doctrine of reasonableness to override administrative decisions, a key and powerful tool the Israeli Supreme Court has traditionally used to review and check executive actions.
A major tool removed.
And another deeply controversial proposal aims to give the ruling coalition decisive, direct control over judicial appointments, essentially allowing politicians to appoint judges who align with their political agenda.
Echoing the Polish model there.
Echoing concerning aspects of the Polish model, yes.
There are, of course, competing justifications for these drastic changes, and understanding them is crucial for a complete picture. Netanyahu's camp vehemently argues that these changes are necessary to curb an activist judiciary that they believe has overstepped its bounds.
The activist judges' argument again.
Arguing it usurps legislative and executive authority, and that these reforms are simply intended to restore what they view as a proper and healthy balance among the branches of government.
But the opposition sees it differently.
Completely. Opponents, who include tens of thousands, sometimes hundreds of thousands, of protesters who have filled the streets for months, along with prominent voices in civil society, counter with dire warnings. They argue that these changes will fundamentally remove effective checks on executive power, enabling potential abuses, endangering minority rights, and ultimately dismantling Israel's democratic safeguards.
Massive protests, huge backlash.
Unprecedented domestic backlash, including widespread strikes and even reservations from military reservists, signaling a deep societal fracture over the very definition of Israel's democracy.
In an extraordinary and truly unprecedented step, Israel's own Supreme Court, as of late 2023 and 2024, took the monumental action of striking down some of the new laws itself.
The court struck down the laws meant to curb it,
directly challenging the legislative will of the ruling coalition. The court will also hear challenges to others, setting up a direct, high-stakes constitutional showdown between the judiciary and the executive-legislative alliance.
Wow, a direct confrontation.
A dramatic and ongoing struggle for the soul of their democratic system, where the highest court is literally fighting for its institutional life and its ability to act as a check.
Israel's ongoing experience underscores with stark clarity how a determined executive-legislative alliance can attempt to remap judicial power, to systematically eliminate perceived impediments to its agenda.
Trying to remove the obstacles.
It dramatically highlights how absolutely vital an independent high court is to maintaining the rule of law, protecting individual rights, and ensuring democratic accountability, especially when facing a determined political majority that views the judiciary as an obstacle.
The court as the last line of defense.
In many ways. The contest in Israel is ongoing, intensely watched globally, but it reinforces the fundamental point. Courts must retain their institutional strength, their independence, and their impartiality to function as true guardrails against potential overreach. Without that inherent institutional strength, they cease to be an effective, independent check on power.
becoming mere instruments of political will.
Precisely.
So when we critically examine these comparative examples and place them into a lens for the U.S. situation, some stark contrasts and deeply worrying similarities immediately emerge.
Okay, bringing it back home.
Unlike Poland, for instance, the United States has fortunately not seen a formal purge or overt legislative court packing of its judiciary. Our judiciary, by constitutional design and long-standing tradition, is still structurally independent.
No direct external attack on the structure.
Right. There hasn't been a direct external assault on its composition by the legislative branch.
And unlike in Israel, where the Supreme Court is actively fighting to retain its constitutional powers against direct legislative attacks, the U.S. Supreme Court's powers are generally considered secure constitutionally.
So the U.S. situation is different in that way.
If anything, the startling and perhaps more insidious observation here is that it is the U.S. Supreme Court that appears to be voluntarily empowering the executive through its own jurisprudential choices and interpretive doctrines.
Voluntarily, so self-inflicted.
Rather than being coerced or externally restructured. This is a critical distinction. The source of the shift is internal to the judiciary itself, a self-imposed recalibration of power.
Yet, despite these different mechanisms and origins, the practical effect can be remarkably, even chillingly similar across these diverse democracies. A governance system where the executive branch faces significantly fewer judicial checks.
Similar outcome, different paths.
The comparative lesson here is profound and unsettling. Constitutional design alone, however brilliant on paper, cannot fully protect liberty and maintain balance if those in power undermine the very institutions meant to safeguard these principles.
Whether through overt manipulation, like in Poland or Israel, or implicitly, like in the U.S. case.
Exactly. Whether through overt manipulation or, as in the U.S. case, implicitly weakening the court's role from within through judicial interpretation.
This immediately raises a critical, even philosophical question about the nature of the threat in the U.S. The concern in America is less about overt external attacks or direct legislative overhauls of the judiciary, which would be immediately recognized and resisted.
People would see that coming.
Instead, the deeper worry is about the judiciary's own jurisprudential choices, its interpretive doctrines and specific decisions that are subtly but powerfully undermining the very system of checks and balances that are meant to guard against executive overreach.
An internal erosion.
It's a self-inflicted erosion, perhaps driven by a particular constitutional philosophy, but an erosion nonetheless.
Okay, let's do the mega recap for this chapter. The comparative flashcards.
Sounds good. First, global relevance. Other democracies demonstrate the vulnerability of judicial guardrails.
Point 1. It's happening elsewhere.
Point 2. Poland. Court packing. The mechanism was legislative executive control over judicial appointments and disciplinary measures. The outcome. Eroded judicial independence. Courts became instruments of the ruling party.
Lesson from Poland. Overt overhaul can neutralize courts.
Point 3. Israel. Judicial overhaul. The mechanism, legislation to strip the Supreme Court's review powers, like the reasonableness doctrine, and control appointments. The outcome, mass public protests, direct constitutional showdown as the SC resists.
Lesson from Israel. Determined governments will try to remap judicial power.
Finally, the U.S. distinction and similarity. The distinction. U.S. lacks overt court packing or direct attacks. The judiciary is structurally independent.
What's the similarity?
The effect is similar, a presidency facing fewer checks. The core concern. The U.S. Supreme Court is voluntarily empowering the executive through its own doctrines, rather than external attacks on the institution.
That internal shift is key.
Very key. Subtle, but potentially just as impactful.
Now, let's move into our conclusion, exploring originalism versus reality and the limits of courts alone.
Okay, tying it all together.
When you listen to the champions and intellectual architects of the Supreme Court's recent direction, they'll often articulate a clear defense. They claim they are simply returning to the Constitution's first principles, faithfully adhering to the framers' original intent.
The original intent argument.
They speak of establishing what they call proper separation of powers and advancing a clear, historically grounded vision of the unitary executive.
They frequently invoke originalism as their interpretative framework, claiming to rigorously follow the framers' intent, looking to the plain text of the Constitution and the historical context of its adoption.
Sticking to the text and history.
The stated goal, from this interpretive perspective, is often framed as preventing rogue lower court judges or activist state authorities from improperly constraining a president's core constitutional duties, thereby restoring executive efficiency.
Making the executive more effective.
The theoretical benefit, as they articulate it, is that a president, insulated from intrusive lawsuits and free to robustly manage executive officials and agencies, is theoretically better able to efficiently carry out the people's elected agenda. It presents a seemingly logical, almost mathematical model of government efficiency.
Appealing to a desire for order and efficiency.
Exactly. Especially appealing to certain intellectual dispositions, those who value clear hierarchical structures.
However, our sources, particularly from critical legal scholars and historians, make it abundantly clear that these justifications often ring hollow when rigorously measured against both compelling historical evidence and the practical, often messy reality of constitutional governance.
A gap between theory and practice.
A discernible gap between the stated philosophy and its application.
This immediately raises a critical question for students of legal philosophy and judicial methodology. How consistent is their application of originalism?
Right. Do they apply it evenly?
The Roberts Court's conservative majority has often demonstrably abandoned its usual textualist and originalist rigor when the subject is presidential power. Instead of strict adherence to the literal text and historical context of the founding era, they've often opted for broad structural assertions that conveniently align with the interests of a particular president or the larger goal of executive empowerment.
So, deviating from their own method when it suits.
One leading scholar notes that the court's methodology in key Trump cases was notably inconsistent with its normal insistence on faithful adherence to text and history, relying instead on what he termed raw consequentialism, meaning they made decisions based on their preferred outcome.
Choosing the outcome first.
Or what they believed would be the best practical outcome if courts or states were allowed to check the president rather than strictly on historical precedent or textual meaning. This selective originalism critically undermines the intellectual credibility of the court's claimed principles.
Suggesting politics over principle sometimes.
Suggesting that the desired political outcomes, rather than the interpretive philosophy, might be the true driving force behind some of these profound decisions. It's a method that picks and chooses its moments.
Yeah.
And that is a significant concern for judicial integrity.
And this selective originalism leads to a profound departure from American historical tradition, a reimagining of foundational principles. Let's be absolutely clear on this point, as it's central to understanding the architect's intent. The founders did not design an unchecked presidency. Far from it.
They feared unchecked power.
They deliberately created a system of robust checks and balances precisely to prevent the concentration of power that they had just fought a revolution against. They explicitly lodged Congress with the crucial impeachment power as a vital check on executive misconduct.
Impeachment as a key check.
And they envisioned that presidents, like all other citizens, could and would be held to account under the law once they left office. The idea that a president could commit crimes and then escape accountability was anathema to their Republican ideals.
Alexander Hamilton, in Federalist No. 69, explicitly stressed this very point, drawing a sharp contrast between a U.S. president and a British monarch. He wrote that, unlike a king, the U.S. president would be liable to prosecution and punishment after his term for any misconduct.
Hamilton himself said presidents weren't above the law.
A foundational insight into the framers' fears of monarchy and unchecked power, and their determination to build an executive accountable to the law. And for over 2 centuries, that principle held firm. Until 2024, no court in American history had ever suggested that a president was categorically immune from criminal law for official acts.
Not during a Civil War, not Watergate. Never.
Not during the Whiskey Rebellion, not during the Civil War, not during Watergate, nor during any other national crisis where executive power was tested. This consistent historical precedent, stretching across the entirety of our republic's existence, speaks volumes about the original understanding of presidential accountability.
So, by placing the president above the reach of criminal law, at least for a broad swath of actions undertaken while in office, the Supreme Court's new immunity doctrine fundamentally turns that foundational principle of accountability on its head.
A complete reversal.
It actively invites exactly the kind of unchecked excess and potential for authoritarianism that the framers explicitly feared and designed our system to prevent in executive power. It creates a zone of impunity.
As President Biden warned, America was founded on the radical idea that there are no kings here, and that every official, from the lowest bureaucrat to the highest officeholder, must answer to the law.
No kings.
Yet the court, through this unprecedented decision, has carved out a space of presidential impunity that is fundamentally incompatible with that core American idea of equal justice under law.
So what could that lead to? What are the real-world risks?
To vividly illustrate the real-world implications, imagine a scenario where a president, emboldened by this newfound immunity, could hypothetically order federal agencies or law enforcement to carry out abusive official directives, like targeting political opponents for spurious investigations, suppressing dissent through coercive governmental actions, or even sabotaging elections, and then later claim immunity.
Claiming immunity for potentially illegal orders.
Claiming immunity from prosecution for those very acts once out of office. This creates a deeply problematic and dangerous zone where the law's reach might effectively end at the Oval Office door.
This is not a robust separation of powers, as its proponents argue. It is a profound distortion of it.
It directly erodes Madisonian checks, referencing James Madison's meticulously crafted theories on checks and balances designed to prevent tyrannical power.
Undermining Madison's design.
And explicitly invites systemic corruption, because it removes one of the most powerful deterrents to elusive power. The ultimate chilling question we're left with is, if a president knows that anything he decrees under color of office, however egregious or illegal, is presumptively beyond the law's reach once he leaves office, what truly deters him?
What stops them from abusing power for personal gain?
What truly deters him from leveraging the vast powers of government for personal or political ends, rather than the public good? What prevents the presidency from becoming an unaccountable, self-serving entity?
The chilling risk.
The chilling risk is a gradual, insidious slide toward autocracy, not through overt revolution or direct military takeover, but by way of legal actions and judicial doctrines that create a space where no court or jury can timely or effectively judge executive misconduct.
Autocracy through legal interpretation.
This creates a profound zone where accountability is severely diminished, potentially leading to a gradual but profound shift in the very nature of our government, from a constitutional republic to something far more centralized and unaccountable, shielded by legal interpretation. It's a direct threat to the very foundations of democratic governance.
Ultimately, the experience of the past couple of years affirms a profound dual truth, a paradox at the heart of our system. Yes, courts can slow the erosion of democracy.
They can put up roadblocks.
We've seen compelling evidence. Brave, independent judges across the country have consistently issued injunctions to uphold fundamental rights and constrain what they viewed as lawless executive acts.
The lower courts we discussed earlier.
The judiciary has often been the last resort, the institution to which beleaguered journalists, vulnerable immigrants, struggling students, and even state officials turn for relief against federal overreach. And often, they received it.
Providing real relief.
These judicial guardrails matter profoundly. They visibly prevented or significantly delayed several anti-democratic measures, from voter suppression edicts to punitive funding cuts aimed at political opponents, from taking full, damaging effect. They created vital breathing room.
But here's the critical, sobering limitation. Courts alone cannot reverse democratic erosion, especially when the highest court itself is actively rebalancing power in favor of the executive.
They can slow it, but not stop it alone.
Especially when the top court is, in some cases, even paving the way for it. As the Supreme Court pulls back on its oversight and diminishes accountability, even the most well-intentioned, constitutionally sound lower court rulings may only temporarily fend off damage, like a leaky dam under increasing pressure.
Just delaying the inevitable, perhaps.
The heavy, solemn responsibility of preserving constitutional democracy cannot and should not rest solely on the judiciary's shoulders, particularly when those shoulders are, paradoxically, shrugging off some of that very responsibility.
So who else needs to step up?
It will also crucially require the active, vigorous engagement of the other branches of government, most notably Congress, exercising its legislative and oversight powers, and ultimately, the vigilant, informed participation of the voters themselves to reinforce the guardrails of democracy.
Congress and the people.
It's a shared responsibility, a collective undertaking.
The sobering bottom line, the central insight we've gleaned, is this. The courts have played a vital role in slowing the slide towards unchecked executive power. They have bought time, they have offered recourse, and they have reiterated foundational principles. But they cannot, by themselves, save the system if the system's own top court is actively easing the way for presidential overreach, if the highest interpreters of the law are creating, rather than closing, avenues for unchecked power.
Okay, final mega recap, the big takeaways for the conclusion.
Let's do it, the flashcard wrap-up.
First, selective originalism. The SE's justification for expanded presidential power often deviates from strict textualism history, using raw consequentialism instead.
Undermining their own stated principles.
Second, departure from founders' vision. The founders intended a president accountable under law post office. Think Hamilton and Federalist No. 69. The SC's 2024 immunity doctrine is unprecedented, creates presidential impunity.
Risking what the founders feared.
Exactly. The risk. Erodes Madisonian checks, invites systemic corruption, potential slide toward autocracy by enabling unchecked official acts.
Third, the dual truth of courts. Lower courts act as crucial slowers. They can and do issue injunctions, upholding rights and delaying anti-democratic measures.
But the limit. Courts cannot reverse democratic erosion alone, especially when the Supreme Court itself empowers the executive.
So, fourth,
broader responsibility. Preserving constitutional democracy ultimately requires active engagement from Congress, the voters, and potentially systemic reforms, not just the judiciary.
It takes more than just judges.
It takes a whole system and the people within it.
So, to bring us full circle, we've explored the complex, dynamic, and ever-evolving interplay between the different branches of government, particularly the judiciary and the executive.
A constantly shifting landscape.
It's clear that the map of power in the United States is not static. It's being actively redrawn by the very institutions designed to maintain its delicate balance.
And understanding how these shifts occur through specific rulings, evolving judicial doctrines, and even procedural choices like the shadow docket is absolutely crucial for any truly well-informed citizen.
For anyone who seeks to grasp the underlying mechanics of our republic.
Given the stark reality that the Supreme Court is, in essence, voluntarily enabling greater executive power, and that courts alone, however courageous, cannot save the system, a profound question naturally arises. For anyone interested in the resilience of democratic institutions, what then is the ultimate enduring safeguard for constitutional democracy?
If not the courts alone, then what?
Perhaps the true guardrail isn't a fixed line on a legal map or a specific constitutional clause, but rather the active, informed, and relentless vigilance of the populace itself, the collective commitment to those foundational principles.
The people as the ultimate check.
Maybe. It's a thought worth considering.
We invite you, the listener, to consider. How will you identify these power shifts as they continue to unfold in the news and in our society?
And more importantly, what role do you believe the individual citizen plays in reinforcing the foundational principles of accountability, the rule of law, and co-equal governance that are the very lifeblood of the American experiment?
Something to think about. Perhaps continue your own deep dive into these critical questions.